In today's video, we'll be discussing the provision regarding appointment of assistant public prosecutors under section 19 of the Bharatiya Nagarik Suraksha Sanhita 2023, which has replaced the Criminal Procedure Code. Under section 18 of this code, provisions are there which provide for appointment of public prosecutors or additional public prosecutors for the High Court at the district level. The central government and the state government both are competent to make such appointments. Section 19 particularly will be discussing, which provides for appointment of assistant public prosecutors to conduct trials in the court of magistrates. Why I am referring to this section specifically? Because there is a provision which provides that even a police officer can be considered for appointment by the district magistrate in certain circumstances. There are normal provisions which provide that central government or the state government may appoint assistant public prosecutors to conduct trials in the court of magistrates. But there is one subsection 3, which empowers the district magistrate to appoint assistant public prosecutors for conducting some case for which suitable assistant public prosecutor is not available. I read out the provisions first. Subsection 3 provides, without prejudice to provisions contained in subsection 1 and subsection 2, where no assistant public prosecutor is available for the purposes of any particular case. So this is the first condition. Despite the fact there are a number of assistant public prosecutors appointed by the state government or even by the central government, if no suitable, I add the word, assistant public prosecutor is available for the purposes of a particular case, then the district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case after giving notice of 14 days to the state government. So this is a new provision that in case such situation arises where appointment of an assistant public prosecutor for a particular case is required to be made, then the district magistrate may go ahead, but he has to give a notice of 14 days to the state government. So after this notice has been given, any other person can be appointed for a particular case, for the purposes of a particular case, to act as assistant public prosecutor. There is a proviso which says that no police officer shall be eligible to be appointed as an assistant public prosecutor if he has taken, thereafter two conditions are laid down. So that means the implication of this proviso is that a police officer can be appointed as an assistant public prosecutor if he satisfies the two conditions given after that proviso. First is, he has taken part in the investigation into the offense with respect to which the accused is being prosecuted. If this is the situation, then no police officer can be appointed. That means a police officer who has not taken any part in the investigation into the offense with respect to which the accused is being prosecuted, he can be appointed as an assistant public prosecutor for that particular case. But the first condition is that he should not have taken any part in the investigation. Even once he should not have been associated. And the next condition is, if he is below the rank of inspector, he cannot be appointed. That means a police officer, inspector or above the rank of inspector, and the officer who has not taken any part in the investigation of the case of the offense for which the accused is being prosecuted, if these two conditions are satisfied, then the district magistrate may consider a police officer for appointing him as an assistant public prosecutor for the purposes of a particular case. So, from the examination point of view, I would say this provision becomes important because the examiner may intend to test your knowledge whether, because it looks a little bit odd that a police officer is allowed to conduct prosecution, but the provision is there. If those conditions or if those circumstances are there, then a police officer can be appointed as assistant public prosecutor by the district magistrate. And I remind you, the notice has to be given by the notice of 14 days. Not only notice of 14 days has to be given by the district magistrate to the state government. That's all for this video. Thank you very much.